Good evening to all Chief Judicial Magistrates, cum secretaries from the states of Punjab, Haryana, and UT Chandigarh. I know it is very difficult to attend to a webinar after working the entire day, but I can assure you that you will find today's topic worth attending. In this webinar, we will discuss the object and purpose of framing the Mental Healthcare Act 2017, which repealed the earlier the Mental Health Act of 1987. The purpose of enacting this act is to provide for mental health care and services for persons with mental illness and to protect, promote, and fulfill the rights of such persons during delivery of mental health care and services and for the matters connected therewith or incidental thereto. As you people might be aware that recently one Pushpanjali Trust has filed civil writ petition in the form of public interest litigation bearing number 110 of 2024 against the state of Punjab and others, whereby Pushpanjali Trust has sought direction against the respondent states to take appropriate steps for establishing community-based group homes for persons with mental illness and frame comprehensive policy as envisaged under Section 19, subsection 3 of the Act. Our Honorable High Court, wide order dated 24 April 2025, has been pleased to pass order to make the judicial officers aware of the statutory duty imposed under Section 27 of the Mental Healthcare Act 2017. Thus, the secretaries of district legal services authorities have been identified as nodal officers for the purpose of disseminating important provisions of Mental Healthcare Act in their respective districts to all the stakeholders. Before we proceed further, let us go through the reasons for enacting this act. India is a welfare state, and our constitution promotes equality of opportunity and participation, including social inclusion for all. The Convention on Rights of Persons with Disabilities and its optional protocol was adopted at United Nations headquarters in New York on 13 December 2006, and it came into force on 3rd of May 2008. India signed and ratified the said convention on 1st of October 2007. Thus, it became necessary to align and harmonize the existing laws with the said convention. Reasons for enactment of this act is that the persons with mental illness constitute vulnerable section of the society, and you will be surprised to know that 1 out of every 10 person is suffering from mental illness of one kind or the other. Such type of persons are subjected to discrimination as compared to others who are suffering from other health disease. They are entitled to be treated at par with other persons having other health issues. The earlier Mental Health Act was not sufficient to protect their rights, and therefore the present act was enacted. Objective of the present act are to promote and protect the rights of persons with mental illness, ensure healthcare, treatment, and rehabilitation of these persons, to provide least restrictive environment for their treatment, improve the capacity of the person to develop his or her full potential, facilitate integration into the community life, fulfill the obligation under the Constitution, obligations under various international conventions which have been ratified by India, regulate the public and private mental health sectors for achieving greatest public health, improve access to mental health care, non-discrimination in health insurance, establishment of mental health system integrated into all level of general health, promote principles of equity, efficiency, and active participation of all stakeholders. Now, we will examine the salient features of Mental Healthcare Act of 2017. This act has been divided into 16 chapters, out of which Chapter 1 deals with short title, extent, commencement, and definitions. Chapter 2 deals with mental illness and capacity to make mental health care and treatment decisions. Chapter 3, it deals with advance directive. Chapter 4, it deals with nominative representative. Chapter 5 is regarding rights of persons with mental illness. Chapter 6, you can call it Charter of Rights, because it directs the appropriate government to enforce the rights of persons suffering from mental illness. Chapter 7, Constituent of Central Mental Health Authority. Similarly, Chapter 7 is regarding Central Mental Health Authority, and Chapter 8 is State Mental Health Authority. The next chapter, which is Chapter 9, it deals with finance, accounts, and audit for maintaining mental health establishments all over the country. Chapter 10, it deals with mental health establishment. 11, Mental Health Review Board. 12. Admission, treatment, and discharge of such persons. 13. Responsibility of other agencies. 14. Restriction to discharge function by professionals not covered by the profession. Chapter 15, it deals with offenses and penalties. And the last chapter is miscellaneous provisions. Now, we shall deal with important definitions to understand this act in a better way. Section 2 provides definitions of appropriate government, which is central government insofar as center is concerned, and state government insofar as establishment in the state government is concerned. Section 2E gives definition of caregiver, which is a person who resides with a person suffering from mental illness and responsible for providing all kind of care to that person. Next important definition is informed consent, which means consent given for a specific intervention without force, influence, fraud, etc. after disclosing to the person adequate information, including risk and benefits. Then a person suffering from mental illness has a right to be treated in least restrictive alternative or least restrictive environment. Section 2O is regarding mental health care, which is analysis and diagnosis of a person's mental condition. Then comes subsection 2, which is regarding mental health establishment. It is regarding a hospital which could be of Ayurveda, yoga, or naturopathy, which is meant for care of persons with mental illness. The most important definition has been given under section 2S, which is regarding mental illness. It says that any substantial disorder of thinking, perception, orientation that grossly impairs judgment behavior, capacity to recognize reality, or ability to meet the ordinary demand of life. It could be associated with abuse of alcohol and drugs. But interestingly, this definition excludes mental retardation, which is condition of arrested or incomplete development of mind of a person characterized by subnormality of intelligence. Therefore, you have to keep in mind the difference, the basic difference between mental illness and mental retardation. Then comes the chapter 2, which is determination of mental illness of a person, which means how to determine the mental illness of a person. Mental illness shall be determined in accordance with nationally or internationally accepted medical standards, and no person shall classify a person with mental illness except for the purpose of his treatment. This act gives discretion to the person suffering from mental illness to choose how they want to be treated. Section 4 provides capacity to make mental health care and treatment decisions. Every person, including a person with mental illness, is entitled to select the procedures under which he is to be treated. Then comes chapter 3, which is regarding advance directive. Advance directive means a directive which has been made in writing regarding the treatment to be given to a person suffering from mental illness. This provision, this provision is applicable to all persons suffering from mental illness except who is a minor. In the case of minor, the decision-making power has been given to his parents or natural guardian. Section 6 is manner of making advance directive. Advance directive shall be made in the manner as specified by the regulations made by central authority. The person suffering from mental illness has been given a right to revoke, amend, or cancel an advance directive made by him regarding his treatment. However, advance directive shall not be applicable for emergency treatment of a person suffering from mental illness. It is the duty of every medical officer in charge of a mental health establishment to follow the advance directive given or chosen by the person suffering from mental illness. Section 11 and 12 gives power to the board to review the advance directive on the applications given by the person who has been identified as mentally ill person. Then we come to chapter 5. As I have stated earlier, this chapter is the charter of demand or charter of rights which has been conferred to persons with mental illness. In the previous act, such rights were not conferred to the persons, and therefore this act can be said a marked improvement with the earlier act. Now we will deal with all the rights of such persons one by one. First has been given under section 18, which is right to access mental health care. Every person shall have right to access mental health care and treatment from mental health services, which is funded by appropriate government. Appropriate government means central or state government, as the case may be. The right to access mental health care means availing these services at affordable cost, good quality, and at a lesser distance without discrimination on the basis of gender, sex, religion, caste, and political beliefs. It casts a duty upon the appropriate government to make sufficient provision as may be necessary, including provision of halfway home. Halfway home is a transitory home between a person's home and hospital where he is given rehabilitation till the person recovers from his illness fully. Section 18, subsection 5, clause B says that treatment to a mentally ill person is to be given which supports person to live in the community and with their families. The basic idea under section 18 is not only to assess mental health care from an establishment run by a central or state government, but make the person comfortable so that he can live normal life with his family. Lastly, but not the least, section 18, subsection 8 provides that appropriate government shall ensure that mental health services shall be of equal quality to other general health services and no discrimination be made in quality of services provided to persons with mental illness. In nutshell, the person with mental illness is to be given treatment as that of any other person suffering from other health issues. Then we come to section 19. As I have already stated, that Pushpanjali Trust, by filing civil writ petition, has sought direction against states of Punjab, Haryana, and others to establish community-based group homes for persons with mental illness and frame comprehensive policy as per provision of section 19, subsection 3 of the Act. Section 19 says that every person with mental illness has a right to live as a part of community life and not to be segregated from the society. Where it is not possible for such person to live with his family or relatives, or if such person has been abandoned by his family, then the government shall provide support, including legal aid, so that the person can exercise his right to family home and living in family homes. Then comes subsection 3, which provides that the government within a reasonable time shall provide all type of support to such persons, including halfway home. Section 20 is regarding right to protection from cruel, inhuman, and degrading treatment. It says that every person with mental illness shall have a right to live with dignity, to live safe and hygienic environment, entitled for leisure, recreation, education, and religious practices. It gives special protection to women like sanitation and access to articles of personal hygiene, particularly when the woman is so required during her menstruation. Above all, the person suffering from mental illness shall not be subjected to compulsory tonsuring, that is, shaving of head hair. Then comes section 21, which is equivalent to right to life provided in our constitution. It says that every person with mental illness shall be treated as equal to persons with physical illness in the provision of all health care, which shall include emergency and other treatments a child under the age of 3 years has a right to live with his mother unless and until the medical professional so prohibits. However, the woman suffering from mental illness is entitled for reunion with her child as soon as she recovers from her illness. Section 22 provides right to information. A person with mental illness or his nominative representative has right to know the treatment by which he is being treated. He can file an application to the concerned board for review of his treatment. He has right to know the nature of his or her mental illness and proposed treatment plan, receive the information in the language which the person understands. Then comes section 23. It is right to confidentiality. A person with mental illness has right to confidentiality regarding his mental health and mental health care issues. This right is subject to some exceptions which has been provided under section 23 subsection 2 from clause A to clause G. Such information can be released to the nominative representative to enable him to fulfill his duties under the Act. Secondly, if release of information is necessary to protect any other person from any harm or violence, or it is necessary to protect the very person, that is the person suffering from mental illness, against the harm being caused to himself, or the information is required by any board, central authority, High Court, Supreme Court, or any other statutory authority competent to do so. Then comes section 24, which is restriction on release of information in respect of mental illness. You can equate this information as right of the persons who are suffering from mental illness. This right is equal to child in conflict with law, whose name is not to be disclosed during and after the trial. No photographs or any other information relating to person with mental illness should be released without the consent of the person suffering from mental illness. Section 25 is regarding right to access medical records. All persons with mental illness shall have the right to access their basic medical records as may be prescribed. However, the mental health professional may withhold specific information if disclosure would result in serious mental harm to the person or likelihood of any harm to any other person. Section 26 is right to personal contacts and communications. A person with mental illness shall have the right to refuse or receive any telephone call, mobile phone call, or visitors which he does not like to meet, or he may limit meeting of such person or receiving of such calls. However, provision of section 26 shall not apply to the visits made by any judge or officer authorized by competent court, members of concerned board, central authority or state authority, member of parliament or state legislature, lawyer, legal representatives, medical practitioners, or any other person duly authorized by appropriate government. Section 27, which is right to legal aid. A person with mental illness is entitled to receive free legal services to exercise any of his rights given under this act, which means a person suffering from mental illness can contact DLSA for the purpose of exercising his rights provided under Section 18 to Section 26 of the Act. And it is the duty of DLSA to provide and cooperate with persons suffering from mental illness. Section 27, subsection 2 says that it shall be the duty of magistrate, police officer, person in charge of such custodial institution or medical officer to inform the person with mental illness that he is entitled to free legal services under Legal Services Authorities Act 1987 or other relevant laws, or under any order of the court if so ordered, and to provide the contact detail of availability of these services. Even under Section 12 of Legal Services Authorities Act, such provision has been made which cast a duty upon DLSA to provide all necessary information, help, and assistance to the persons suffering from mental illness. Then comes Section 28, which is right to make complaints about deficiencies in provision of services. Any person who is aggrieved from the services provided to him under Mental Health Care Act can make a complaint to the board if he is not satisfied with the services. Thus, it is the duty of DLSA to provide all type of legal aid to such persons in the case of necessity and for the purpose of filing any complaint. Then we comes to Chapter 6, which is duties of appropriate government. It is the duty of appropriate government to promote mental health and preventive programs to create awareness about mental health and illness and reducing stigma associated with mental illness. It is the duty of appropriate government to take all measures as regard to human resource development and training, etc., and to coordinate with other government departments as per provision of Section 32. Then comes Chapter 7, which is regarding establishment of Central Mental Health Authority. Functions of Central Authority is to maintain, register all mental health establishment. All mental health establishment are to be compulsory registered, and it is the duty of the Central Authority to maintain such registers, develop quality and service provision, supervise all mental health establishment, train all persons, including law enforcement officials, advise the central government on all matters relating to mental health care and services, discharge such functions with respect to matters connected with mental health. Section 44 provides that central authority shall meet at such times, but not less than twice a year. Then Chapter 8 deals with formation and function of state mental health authority. Similar functions have been assigned to state authority as assigned to central authority with respect to the functions of central government. However, the state authority has been directed to meet not less than 4 times a year as compared to central authority, which is required to meet not less than twice a year. Chapter 11 is regarding mental health review boards. Section 73 says that the state authority shall constitute boards to be called mental health review boards, which shall be headed by a district judge or the officer of state judicial service, a representative of district collector, 2 members out of which one should be psychiatrist, and such persons as in the opinion of the state mental authority to be fit to be appointed as a member of the board. Section 82 deals with powers and functions of the board. It says that it is the duty of the board to register, review, alter or modify any advance directive made by a person suffering from mental illness, to appoint a nominative representative, to receive and decide the applications regarding deficiency in services, and all other acts which are incidental thereto. Chapter 12 deals with admission, treatment, and discharge of such persons. Section 95 of the said Act prohibits certain procedures, which is usage of electroconvulsive therapy, which is commonly called ECT, giving of shock to the persons with mental illness without the use of muscle relaxant and anesthesia. Earlier, the person suffering from mental illness were subjected to ECT without first administration of anesthesia. On the other hand, ECT to the minors can only be given with prior permission of their guardian or parents. A person with mental illness is not to be chained in any manner, and it further prohibits sterilization of men and women for the purpose of treatment. Section 97 deals with restraint and seclusions. A person with mental illness shall not be subjected to seclusion or solitary confinement, and it is the duty of the government to provide all necessary environment for the unification of such persons with their families. Then comes chapter 13, which is responsibility of other agencies. Section 100 says that if a police find a person wandering or roaming within the area of his police station and the police has reason to believe that he is suffering from mental illness and incapable of taking care of himself, then such person shall be taken into protection, and it is the duty of the police to inform such person the grounds for taking him into protection or to inform his nominative representative or family members, and thereafter such person shall be produced to the nearest public health establishment and not later than 24 hours from taken into protection. Above all, the police shall not keep such persons in any kind of custody or prison. Then subsection 7 of section 100 says that first information report of a missing person shall be lodged by the concerned police station who have duty to trace the family of such person. Section 101 mandates that the police is to produce such person before magistrate if he is found being ill-treated or neglected, and thereafter it is the duty of the magistrate to convey such person with mental illness to any mental health establishment for the purpose of knowing the extent and nature of his mental illness. Section 103 provides that prisoners with mental illness must be kept in a separate ward in the jail, and if it is not possible, to a separate ward in the jail of some other district. Section 104 is persons in custodial interrogation institute. It says that when it appears that a person is suffering from mental illness, then such person is to be produced before nearest mental health establishment run by appropriate government. On the other hand, section 105 provides that when question of mental illness is raised in any judicial process, then the court dealing with the matter shall refer the same for further scrutiny to the concerned board, and the board shall, after examination of the person, submit its opinion to the concerned court, and thereafter the court is empowered to pass appropriate orders. Chapter 15 provides penalties and punishment for violating any provision of the Act. The offense is to be tried by the magistrate and it is punishable up to imprisonment for 6 months or with fine of ₹10,000, and for subsequent contravention up to 2 years with fine of ₹50,000. If the offense is committed by the company, then the officer in charge of the company is liable for punishment. Before we come to close this webinar, there is a case called Accused X versus State of Maharashtra 2019, which you can see at entry number 3, important judgments 2019 7 SCC. In this case, a person was held guilty for committing rape and murder, and he was sentenced for capital punishment. The person filed a review petition before Honorable Supreme Court, wherein it was contended that the convict is suffering from mental illness and therefore he should not be given capital punishment. Honorable Supreme Court held that capital punishment is to be given to those who can understand the consequences of their acts and commissions, but not to someone who does not understand the consequences of his acts. Therefore, whenever a case is detected by the court, he shall be referred to mental health establishment, and once a report is received, then appropriate order is to be passed. If you have any question or query, you can ask. Thank you.